Good morning, everybody, and welcome to another edition of Monday Morning with Mo. I am Mo DeWitt, and it is Monday morning, so we're here to answer your legal questions as always. And if you do have any legal questions, you can give us a call, 407 536 6737. Leave those voicemails for us, or email us at ask@dewittlaw.com. Don't forget, December 6th, this Sunday, we have the Fun Spot event. So I think we only have about 10 tickets left, so if you want to get in on that, go to justcallmo.eventbrite.com. Should be a great time. We're trying to be COVID safe as well, so masks are required. But we'll have some goodies for everybody out there. Free day at Fun Spot. Should be a lot of fun. So hopefully you guys can join us this Sunday. I think it's in the afternoon sometime. Check the website, justcallmo.eventbrite.com, and you can register there. Registration in advance is required, so make sure you do that if you want to come out. So I hope everyone had a great Thanksgiving. Hopefully relaxing, uneventful. We just stayed at the house here, but we discovered that one of our bathrooms is on a septic tank. So that was some exciting news. Did not know that. Did not know that we had a septic tank on the property. So as you can imagine, we had some plumbing issues as well. So anyways, let's get to it. Oh, last thing. If you want to join our texting service, I promise I won't spam you. You can get first for all event information, giveaways, all that kind of stuff. Just text to 407-698-3984. It's 407-698-3984. That is our new texting service. So you'll get all information about the events we're doing, all that kind of fun stuff. You'll be the first to receive those. And again, I promise I will not spam you on it. So anyways, let's get to this week's legal questions. First up, we have Amber. And Amber says, my situation is a bit complicated, so I need to get informed. Well, that's what we're here for, Amber. I'm currently staying in Florida, but haven't been here for the last 6 months. I was residing in Illinois for the past year with my husband. He is residing there as of now. One lawyer told me that Florida doesn't have jurisdiction, but I don't have the income to go back to Illinois. If you could please advise me as to what I'm supposed to do or point me in the right direction. Thank you in advance. All right, Amber. So that attorney is correct. Typically, you do not have jurisdiction in Florida unless you've been here for 6 months, jurisdiction to file for divorce. Now, there are some minor exceptions to that if there's child endangerment or child welfare issues. But for divorce, typically you have to live here for 6 months prior to filing. And then you would still have the issue if your husband never lived here, you still may not be able to file here. Typically the proper place to file is the last place that you guys live together as husband and wife. So in this case, it seems like that was Illinois. You guys lived there for the past year. I don't know Illinois law, but I'm assuming Illinois would most likely have jurisdiction in your case. Obviously, the problem arises that you don't have the funds to go back to Illinois to file for divorce or go forward with the divorce, by flying back there. So I would recommend contacting an attorney up there, or possibly, if you can't afford an attorney, contact the courthouse, see if there's a legal aid program or something along those lines that may be able to assist you in filing for the divorce, and then asking for temporary support. So anytime a divorce is ongoing, you can ask for temporary alimony or temporary spousal support, which is the same standard as regular spousal support, at least here in Florida. It's based on need and ability to pay. And so that may be able to give you the funds. And you can also ask for temporary attorney's fees if your husband has the ability to pay for you to hire an attorney. So if you can go ahead and file that, then you can try to get temporary spousal support and temporary attorney's fees, so that you can go ahead and litigate the case in Illinois, which I think would probably be the proper jurisdiction. But that's basically what you're going to need to do. It may be a little rocky getting it started, but if you can afford an attorney, go ahead and hire one. Ask them those questions. Can you do a temporary relief motion to ask for temporary support and temporary attorney's fees? If you can't afford an attorney right now, contact legal aid, see if there's other, either pro bono programs or discounted legal service programs that may be available. Usually I would call the courthouse. Sometimes they do have a self-help center or something along those lines that may be able to point you in the right direction. So, excuse me. So Amber, thank you for your question. As always, if you guys have any legal questions, go ahead. You can leave a voicemail for us at 407-536-6737. Let me get a little water there. Or shoot us an email, ask@dewittlaw.com. Next up, we have Jeff. So Jeff says, my wife was in a car accident 3 weeks ago. From a stoplight, she was turning left, and the other lady said she ran a yellow light, and my wife ran into her. The collision caused the lady's car to spin and hit another car in the turn lane. The lady who ran the yellow light has hired an attorney for a claim against me, my insurance company. Those pesky attorneys. Florida Highway Patrol determined no fault. And we already replaced our front bumper and a couple other things with less than $1,000 in damage. I'm certain that the insurance company will handle them directly through the waiver of subrogation and our policy, but I'm concerned that our rates will increase even though my wife was not at fault. FYI, my wife ran the latest traffic record for Orange County, and she has at least one instance of running a red light, driving with a suspended license, or something like that. Can this information be used against her as a potential frivolous claim? So I'll start with the second part of the question first. So typically past bad acts or prior bad acts cannot be used against you in court. The only exceptions to this typically are if you're convicted of a felony, those can be used against you, or if you're convicted of a crime of dishonesty. Typically that's theft or perjury or something along those lines. So otherwise, just because someone had a prior bad act, in this case, running a red light or driving with a suspended driver's license, that doesn't have really any influence or relevance to whether she was at fault or not in this car accident. So, that information really wouldn't be relevant, and you wouldn't be able to use it in a court of law. In Florida, there's an evidence code, and typically the judge would probably keep out that evidence because the prejudice outweighs the probative value. So that would be excluded from any court proceeding, most likely. As far as your insurance rates go, so typically the insurance company can only raise your rates if they determine that you were substantially at fault. So the first question we always have is, what does substantially at fault mean? Well, the statute doesn't really define that, but we could assume that probably means 51% at fault or more. Just because you were involved in a car accident, the insurance company is not allowed to raise your rates unless they make that finding that you're substantially at fault. So, even though your insurance company may resolve the case, and they may say, this is what we call a nuisance value case, where we're just going to throw a few $1,000s at it to get it to go away. You want to clarify with the insurance company whether they're finding you substantially at fault or not. If they don't find you substantially at fault, and you may want to dispute that based on the facts and the police report and everything else, if they don't find you substantially at fault, they cannot raise your insurance rates. But obviously that's always a tough fight, because really your only remedy would be to sue your own insurance company at that point if they did try to raise your rates, and depending how much the rates went up, it may or may not be worth pursuing. So that's the legal answer. Hopefully that helps. But given that Florida Highway Patrol didn't find anyone at fault in the accident, you certainly want to cite to that. And even though I would say this is America, anyone can sue anyone for any reason. Just because they hired an attorney and they're going to pursue a claim doesn't mean they're right. Doesn't mean that your wife is at fault. So best of luck. Thank you for the question, Jeff. As always, if you guys have any legal questions, give us an email, shoot us an email, ask@dwitlaw.com. Leave us a voicemail, 407-536-6737. Or you can always just call the office during the week, 1-800-DeWitt-LAW, or our new number, 1-866-CALL-MO. So, plenty of ways to get a hold of us. So no voicemails this week, but kind of a slower week on the legal questions with Thanksgiving and all. But we still got a few here. So our last question this morning is from Ryan. So Ryan says, my wife and I can't talk this morning. My wife and I sold our home and split the proceeds shortly before filing for divorce. We each received $150,000 from the sale of the home. Now that we have moved forward with the divorce, her attorney is coming after me for alimony and attorney's fees. Do I have any defense since she received $150,000 from the sale of the home? So both alimony and attorney's fees in Florida are based on need and ability to pay. We talked about that a few minutes ago. So, for the attorney's fees portion of it, arguably, if they're coming after her or him for temporary attorney's fees, meaning attorney's fees while the case is being litigated, and she has $150,000 in the bank, she may not have a need for him to contribute to her attorney's fees, because it's based on need and ability to pay. So that $150,000 that she has in cash on hand that she's able to use certainly reduces your liability to have to pay her attorney's fees. It could also potentially reduce your liability to have to pay alimony. But again, alimony is going to be based on what her need is, and do you have the ability to pay to satisfy all or some of that need. So if the $150,000 eliminates her need entirely, then there may not be any alimony claim. But alimony is going to be a little bit more of a complex analysis because we have to look at first of all, what was the length of the marriage? What type of alimony is she entitled to? Is it a long-term marriage when she's entitled to permanent alimony, mid-term marriage where she's entitled to durational alimony, or short-term marriage where maybe it's just, bridge the gap or rehabilitative alimony or something along those lines. So that would be the first question I would have is, what length of marriage are we looking at here? From there, we have to look at the standard of living during the marriage, what her ongoing monthly expenses are going to be, and, really what is she seeking alimony for? Is she seeking alimony because she doesn't work at all? Is she seeking alimony because the husband makes more, or maybe the incomes are similar? So there's a lot more information we need here to analyze this. But when it comes to attorney's fees, if both parties, especially temporary attorney's fees, if both parties have $150,000 sitting in the bank, I think a judge is not going to be very likely to award one party temporary attorney's fees because they have the ability to pay their own attorney's fees at that point in time. So the whole purpose of temporary attorney's fees or temporary support in general, which as we saw in the first question today, is so that the parties have equal access to the courts. The courts never want one party to be in a position where they can't afford representation of a similar level of their spouse. And they don't want a situation where one party is basically forced to settle because they can't afford an attorney or afford proper legal representation. So that's the purpose of temporary attorney's fees. But if both parties have a substantial amount of cash on hand, that eliminates the necessity for temporary attorney's fees, in my opinion. Obviously, there's a lot more information here that we need to know from this question, but hopefully that gives you some insight, Ryan. And, as always, if you have any questions, give us a call at the office. I'm happy to talk to you and give you some more of my thoughts and see if we can help you at all. So anyways, thank you guys for joining us as always on another episode of Monday Morning with Mo. Keep the emails coming, ask@dewittlaw.com. Leave us some voicemails, 407-536-6737, and we'll play those on the show. And if you leave a phone number, I'll also call you back, but I will cut the phone number out of the show so that everybody doesn't have your phone number. So again, thank you for joining us. I hope to see you guys out at Fun Spot on Sunday. And otherwise, have a great week. Stay safe out there, and we'll see you next Monday for another episode of Monday Morning with Mo. Take care, guys.